up with anything yet.
George, the argument of the lawsuit is, the major argument is that this official, cabinet level official, was leading the mob that committed an act of genocide, organized mob, and the witnesses have for the last 26 years confessed repeatedly about the presence of these high-level officials in the mob. Is this a winning argument, or do you think this doesn't carry much significance?
Well, it's holding him accountable for personal actions. If he wants to argue that he was in some way performing official government duties,
yes,
then that's a hell of an indictment of the Indian government. That would be a very interesting case at that point.
But he could make that argument, counter-argument, that he was just making sure that the mob doesn't get chaotic, and he was trying to help.
That is exactly to the media. He is saying this, that I was not there to incite the mob, I was trying to
calm down the people, the riots occurred, and
wasn't very successful, was it?
Well, if that's his defense, it would be interesting to have him come to court in the United States and make that argument.
Witnesses said he was shouting. He was part of it.
No, actually he was leading the mob.
He was leading them, telling them what to do, where to put the arson oil, and how to burn people alive. He was providing moral
3 or 4
support.
were burnt in front of him.
I think do you think the government made a mistake by promoting these perpetrators of genocide to very high-level cabinet officials positions? And had the government not done this, maybe people would have accepted this as sort of riots and not genocide.
Well, yeah, I think it's an incredibly stupid act on their part, because it sort of implies that this is a reward for past work.
Actually, yes, it is a reward.
It elevates those actions to official sanctions of government. That's a terrible, not a very smart government.
Barbara Crossett of the New York Times was there, and she reported that she was surprised to see that the Home Minister getting elevated to what?
Prime Minister. He became Prime Minister, yes. Actually, Barbara Crossett was the New York Times bureau chief in Delhi at that time.
Yes.
And in her reports or dispatches from there, she described that how the complacency of the ministers and all to the lower level.
She was shocked to see the promotion.
Narasimha Rao was the Home Minister in November 84, and he became Prime Minister of India in 91.
Yes, and he was rewarded.
And all those major killers like Jagdish Titler, Sajjan Kumar, H.K.L. Bhagat were awarded the cabinet berths under Narasimha Rao's government. Even Rajiv Gandhi, earlier, immediately after that, elections were held. Rajiv Gandhi won the elections with 2/3 majority, and all of them were cabinet ministers in the federal government.
The fact that they could do this and felt that they could promote these people with impunity is a reflection, really, for the world at large to see how much moral corruption exists in the existing government.
And I think
that's a systematic problem.
One part which is that during this period, from 1984 till 2011, 12 prime ministers India have seen. They came up with 12 different commissions and committees for inquiry, from Mishra Commission to Nanavati Commission. But all of them escaped due to their political link to the Congress party. So,
you know what it reminds me of is that right after a couple of the top officials in the Darfur genocide were indicted by the International Criminal Court, they were elevated to higher positions in the Sudanese government by Bashir. I mean, this is a reward for committing mass murder.
You know, another thing you have to think about is that it may be a reward, but it may be also a way of putting a noose on someone, so that they don't cause further collateral damage to those that are already in power. From their standpoint, as they say, keep your friends close, but your enemies closer. So from that standpoint, I think that what's happened in India, what's happened in Sudan, what's happened in a number of other countries where these genocides have taken place, is that those leaders have recognized that these people, while these trials and these procedures are moving forward, that they could become tremendous liabilities to them. So it's better to keep them within range rather than just let them roam free. And to be honest with you, I think it's I think that this issue with regards to Mr. Nath, I think would open up, quite a Pandora's box for, I think, many of the others that have been mentioned just recently that were part of the genocide that did occur in India.
If U.S. government don't gives him immunity and he doesn't show up here, what is the status of the extradition treaty in that case? That still, if there is a U.S. court order, he didn't come up in the court.
In this case, it wouldn't be extradition because it's a civil case.
Yep.
It is under the Alien Tort Claims Act. Now, they've also brought the case under the Torture Victims Protection Act, which is a criminal act.
Civil or criminal.
Civil or criminal. So in that case, they've got a different situation. That's a more recent law. The Alien Tort Claims Act is, there's two strands of decisions in it. One is in the Second Circuit in New York, and that's why they brought this case in New York, in which it started out with the Filartiga decision in 1980, in which a torturer in Paraguay was found liable for torturing a person who was living in the United States when Filartiga, the torturer, actually came to the United States, and he was held liable. Unfortunately, there was another case that went all the way to the Supreme Court called Sosa that went the other way in the sense that the Supreme Court ruled that the law that was applicable under international law had to be the law of the 18th century.
I see.
Well, the law of the 18th century didn't include genocide, of course. So you've got two strands of law here in conflict with each other. So that's why they brought this in the Second Circuit. I think they've actually got a pretty good case in the Second Circuit.
What if the case against this cabinet level official has not been filed for the past 26 years in his own government where the genocide occurred? Does that dilute the significance?
It's irrelevant for either of the two statutes as to whether or not any case has been brought to him in India. The issue with the Alien Tort Claims Act is even if he's not physically in court, he's already been lawfully served. Consequently, if he doesn't want to defend himself, then it's an opportunity for the plaintiffs. This isn't a prosecution in the sense of a criminal court. It's plaintiffs bringing an action for damages. All of that information will go into the record unopposed for any reason. Consequently, he will, have if he has assets in the United States, they'll be frozen. If he has assets that are in any way traceable, that can be captured, they will be, because he will have a judgment against him if he fails to appear to defend himself.
But there is no way to bring him here.
Precedent is much more important than any monetary damages, because then anyone, any place in the world knows that they can't escape the long arm of justice at some point.
That's right, and that's why those two statutes are so important.
So will the impact of this case affect the other perpetrators of genocide in this case, particularly Dr. Sen, do you think?
Oh, yes, certainly. I think as Anne said...
So will the Indian government then take actions against those people, or how?
No, I don't think so. As far as Indian government goes, after the Nanavati Commission report, they said it is over. And even Indian Prime Minister said, forget about the past and move on. And from that point, we don't expect anything from there. But certainly, these perpetrators of heinous crimes against the Sikhs or Muslims or Christians or untouchables in India, they'll think thrice before coming to the United States, that they'll know that already, as has been said, precedent has been set. So, but we don't expect anything from the Indian government.
I agree. I think that they will definitely think twice, but I also think that they'll probably start to look at how their assets are arranged and the rest of it to try to work on that. And I think overall, though, that this case, as I think was correctly noted, does have some merits relevant to it. And I think that if any progress is made with this, that this could be really a hallmark for opening up the dialogue to others, because Mr. Nath won't just be questioned about his own activities, rather that of his colleagues and who asked him to do what and the rest of it. So at this point, I think that this is a great step in the right direction.
Also, the plaintiffs can either be citizens or non-citizens of the United States, a critical component, because those who are bringing these actions don't have to themselves even be resident here.
Another case that is interesting is the case of the massacres in Gujarat, in which Prime Minister Modi of Gujarat, Chief Minister of Gujarat, was actively participating in directing these massacres. We found out that at Genocide Watch, that he had a 10-year multiple entry visa to the United States. He was about to come to give a speech in Florida, and I called up the head of the consular service at the United States State Department. I said, "You've got to yank this guy's visa. Take his visa away." They did. And so Modi literally cannot travel to the United States now.
Yes.
They did so under the International Religious Freedom Act.
That's right.
Because of the persecution that he perpetrated.
Yep.
Yeah, and from a standpoint of application of U.S. law to other instances, in the case of Ukraine and some bad actors in Ukraine, one of the levers that we had from here was a lot of these folks invest in the United States. They buy real estate here.
Right.
They put money, stocks, because of our stable economic situation, they hide their assets here. And when they do, you can get to them. So these